Good afternoon, everybody. This is Rachel Sterling, and you have joined the 2025 webinar, the Tenant Landlord webinar series. It's our first installment this year. We're going to be going over the 2025 legislative agenda. Session just started yesterday, sort of. We'll get into that. So this is good timing to see what's kind of on the docket for us this year. So we'll give it a couple of just seconds to get everyone in and situated and settled before we jump into it. The session is being recorded, as I'm sure you've heard as you were coming in. Uh, so we will have it up available on our website in a few days. But if you can just sit back for another probably 10 seconds, we'll get this party rolling. All right, I think that's probably long enough. So, again, for those of you who were just joining us in, my name is Rachel. I am an attorney here at Homeline. This is the first installment of the 2025 Tenant Landlord Law series. We are joined today by our Homeline Policy Director, Michael Dahl, and Homeline Policy Attorney, Larry McDonough, who will be discussing the 2025 legislative agenda that we've got planned out. Couple of housekeeping things first. In case you're new here, what is Homeline? We are a nonprofit that helps tenants in Minnesota kind of navigate what their rights are under Minnesota tenant landlord law. So we offer free, brief, limited legal advice via phone and email in 4 different languages. Um, this is our phone number, and then the phone numbers for the various language lines we've got, as well as the website for how you can fill out our email and attorney form. Upcoming webinars. So obviously new year, new series. We're going to be diving into a bunch of really interesting topics in the next few months. So next month in February, we're going to be doing something brand new, and we were really excited about trying this out. So instead of having a specific topic that we're going to be covering, we're actually going to be having a question and answer session. So if you are someone who's got questions and you would like kind of a I guess, live answer, this is the time to ask it that, so we are excited to be offering that. The registration is going to be up on our website starting this afternoon. So please feel free to register for that. Bring your questions. We'll have a panel of attorneys who are experts in this field to kind of dissect and discuss your questions. So bring it on, I guess. In March, we'll have someone from legal aid kind of going over the basics of some of the various more common housing subsidy programs that are out there, like Section 8 or GRH or something and things like that. And then in April, we'll have someone from Housing Link come and kind of do an overview of the current housing market. So that will be really interesting as well. And you can go to our website and learn more at homelinemn.org. All right. Like I said before, this session is being recorded. So we'll get it up on Homeline's website in a few days as soon as we're able to get it off the cloud and all that. If you have questions, we love questions, encourage questions, but if you have questions about what's going on here today, please feel free to ask those in the Q&A function. So if you ask them in the chat, I will probably miss it. I will feel badly that I've missed it, but I will probably miss it. So please use the Q&A function that is at the bottom of your Zoom screen. It should be um, a little like question box or something like that, but it says Q&A. So please use that to ask any questions that you have, and we'll have questions, so bring them on. We are not going to be applying for CLE credits today. So if you are here for that, we'll get you next time. All right. And I think with that, I am done with my housekeeping. I'm going to turn it over to Michael Dahl, our policy director, so he can talk more about the 2025 legislative agenda and session. All right. You're on mute, Michael.
Taking myself off mute. Thank you. Um, well, thank you for attending today's webinar, and it's a chance for us to talk about Homeline's legislative agenda in total, as well as some specific things we're going to be asking for at the legislature that we would love to have your help on. Um, but while we're trying to get certain things to move forward this session, it'd be incomplete to actually move forward without talking about the politics that are happening at the legislature. And so I wanted to start off with that, just so folks know the context that many of our policies are going to be set within, at least for the next few weeks. And really, if you haven't been following the news, you may not know there's a power struggle that's happening in the Minnesota House of Representatives. Um, Before the past little over a week or so, Democrats and Republicans had a power sharing agreement in the House where each committee had a chair and a co-chair from each party, and membership was split 50-50 between the two parties. But after that process was completed, Ramsey County DFL Representative-elect Curtis Johnson resigned from his position amid some residency questions and whether or not he actually lived in the district. And so rather than follow that process through the courts, he resigned his position, and that meant that the Republicans now have a one vote advantage, but it's very likely to be a temporary advantage. Um, there's going to be a special election on January 28th in what is considered a uh, quite Democrat leaning uh, 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 the Democrat is likely to win, and the balance will again be in place. So yesterday, the House Republicans showed up at the Capitol. It was supposed to be the assigned beginning day of session, but the Democrats have boycotted the proceedings. I'm on the next slide, Rachel. Um, that Democrats boycotted the proceedings, saying the Republicans were not going to meet their part of the equal power sharing deal. And there's also a dispute about whether the Republicans are going to support seating a legislator, Representative Tabke, who was elected to his position, but there were 20 ballots that had gone missing. Uh, there were some people who said that who were amongst those 20 ballots that disappeared or went into a circular file, and so a number of people had testified that they were amongst the group of those group of ballots, and so Representative Tauke was declared the winner by a Ramsey County, I'm sorry, a Dakota County judge. And so um, that's part of what's at play at the Capitol right now. Next slide. Um, the House of Representatives has to be convened by the Secretary of State. And the Secretary of State had written to the legislature beforehand saying that if quorum wasn't achieved, which is 68 votes, that they would not be able to uh, they would not be able to convene the legislature or start the legislative session. And that's what happened. There were 67 legislators there. They needed 68 to start business. So the Secretary of State said he couldn't convene the legislative session. However, the Republicans questioned whether or not that was an accurate way for things to be running at the time. So they elected Representative Dameth, the Speaker of the House, and they're asserting that they have the power to restructure the committees in a different way than they had agreed to under the power sharing agreement. And that this would not just last for until the special election is held on January 28th, but instead that it would be um, power for the rest of the 2024-2025 biennium. So anyway, there are many twists and turns, and likely things are going to be have to be settled in the courts. But the Republicans have already indicated that they're paying attention to what is happening in the courts, but they may not always agree with what happens there. So next slide, and I'm looking at the one that says "Do the right thing," and this comes to sort of the start of where I'm going to be talking about our legislative agenda. Yesterday in the Senate floor, where things are much more calm. There is a power sharing agreement there because there's a tie right now because of the death of Senator Dietzick. Um, that power sharing is going to last until the election is certified for the space that her office, she's no longer in office and they need to elect someone new. But yesterday there was a lot of kind words that were said about Senator Dietzick, and one of our chief authors in the Senate, Senator Mohammed, shared a remembrance of Senator Dietzick when she said that Dietzick told her to not worry about the politics, not worry about the noise, but just to do the right thing. And so Homeline's legislative agenda is for us to do the right thing. Moving on to the next slide. Here's where we start to get into the substance of what's on Homeline's agenda. And there are things that we are going to lead on. There are things that we are going to be a strong coalition partner within. And then there are items that we're going to be supporting. And first off, I want to talk about where Homeline will lead. We are going to advance measures that are in our Minnesota Tenant Bill of Rights, which is a different packaging of a set of proposals that we came forward with last year. There's a number of items of that 60 or 70 things that we said would actually introduce the level of balance that we think needs to exist between tenants and landlords. As we often say, the landlords write the leases, and we need state law to protect tenants in those situations. And so, in this Tenant Bill of Rights, which you can locate by going to our website at homelinemn.org, and there's a policy tab that you can drop down to, and it has a link to our Minnesota Tenant Bill of Rights. And those rights that we assert tenants should have are, first of all, the right to a fair application and rental process, the right to a fair lease, a right to a fair habitable home, reasonable rent, a right to balanced power in court, safeguards against eviction, and clear rules. I'll be talking more about each of those a little bit later, but we have a proposal that talks about some of the things that we think might be more agreeable to both Democrats and Republicans for us to come together on. But if there are legislators that want to work on other items that are in our Tenant Bill of Rights, um, we will certainly partner with them to try to get those things passed into law as well. The second item that we'll lead on deals with the tertiary renters insurance policies that sometimes landlords require. And some of the uh, renters insurance covers any type of accident that happens of both the tenants, the unit the tenant is in and the units around it that might be damaged if, let's say, a fire happens. Um, and all of the policies actually cover that are, I'm going to back up. Tenants sometimes buy renters insurance for their property. There's a second form or a tertiary form of uh, insurance that covers the unit itself that the landlord owns and the surrounding infrastructure for other apartment units. And almost all of those policies cover something if, like, let's say a fire starts by accident. But if there's water damage that's done in an apartment and surrounding apartments, those surrounding apartments may be covered by the landlord's insurance, but there's supposed to be renter. We're pushing for the renter's insurance that tenants buy, that it would cover their unit as well, so that if there was water damage to their unit, they could actually cover the cost of that through their renter insurance. And then the last thing that we're going to be asking for is funding for a statewide tenant hotline. Um, we think that much as Minnesota Housing appropriates funds for things like workforce housing or family homeless prevention or um, different subsidies for people with severe and persistent mental illness, there should be just a line item in there that says a tenant hotline needs to be covered under state law. And so we're going to be working to pass that measure. Next slide. Then there's going to be some items that we partner on and play a strong coalition role. And first is that we want to guarantee that there's a source of income protections. We've been working on this for years. We want to clarify the state's civil right law that ensures that landlords cannot refuse to rent to someone or otherwise discriminate against them because they receive and use rental assistance to pay their rent. Often this is in the form of Section 8, but there are other subsidies that come from the state, from a locality or a county that would also be covered if there's a subsidy to help pay rent. We don't think that landlords should be able to discriminate against the person and not rent to them. So that's called source of income protections. And if anybody is interested in finding out more about this, please contact me. My email address is michaeld@homelinemn.org. I'll be saying that later in this webinar as well, but we want to talk to you. We also want to talk to you if you are interested in the state having just cause eviction protections. Again, a large coalition of organizations have come together to support this. And it says that there be safeguards to tenants from extremely fragile leases by prescribing that landlords cannot issue notices to terminate their tenancies or refuse to renew the leases um, unless there's a just cause for doing so. Imagine a homeowner being told um, by the bank, you got to move within 30 or 60 days. This home is not longer going to be no longer in years. We don't want to do this alone anymore, and so you got to pick up and go elsewhere. Well, that doesn't happen if the homeowner is paying the bills, and we likewise say that if a tenant is paying the bills, doing the general upkeep, and not violating the lease, that there should only be a just cause reason to evict them or displace them from their apartment. So that's another thing that we'll be playing a partnership role on. Next slide. Um, we also want to make sure that there is enough money to actually solve the housing crisis that we are in and have been in for a very long time. And one way we can do that is actually raise money through a state sales tax. And there's an effort that's led by the Minnesota Housing Partnership and likely a couple other organizations that I'm not calling, bringing to the forefront of my mind right now. But we want to have a constitutional amendment that says that 3/8 of 1% or 38 cents for a $100 bill would be used to meet a few different areas. They would remove the barriers to home ownership. They would make rental housing safe and affordable and protect vulnerable households and communities from displacement and homelessness, sometimes through emergency rental assistance. That uh, constitutional amendment needs to pass the legislature before it could actually be put on the ballot for voters to decide if they want to have this tax. And it would raise between, I think, 400 and 500 million dollars per year to to get the adequate funds to help us make a dent in the housing crisis that we're currently in through those three strategies. And then the last item of support that I'm sorry that we're doing the coalition work in is secure additional money for emergency rental assistance. We've had this for a number of years in place since the pandemic, but there are still a large number of evictions taking place each year, and more emergency rental assistance to help people stay housed and stably housed out of homelessness is something we strongly support and want to play an active role in coalitions with. Next slide. And by the way, pretty soon I'm going to be sharing some of these presentations with Larry. I'm just talking through our general legislative agenda, and then Larry will join in and talk with y'all as well. Okay, so there are some items that we're going to support, and one is that we think there should be a statewide landlord database. This is something that the city of Minneapolis is pushing for. The rental market is not as transparent as it needs to be, and a database would give decision makers, but also the public, the information they would need to know whether or not they want to rent from an apartment unit. And it would include things like financial interests, affordability of of the rent of a certain place, and the track record of a landlord, not just in the community that they're renting, but there may be other communities that they have properties in, and a tenant and decision makers would get the chance to see what uh, what the history is for a particular landlord. We think that these measures would strengthen enforcement and provide transparency. And so we're working with the city of Minneapolis on this item of support. Next slide. And then the last thing that is on our, thus far, on our legislative agenda, which may expand a little bit as session unfolds and we see a bit more of the legislation that might be something we want to support or be a coalition member in. But the last item that we have right now is the Minnesota Fair Chance Access to Housing Act. And this would make sure that landlords take a look at applications and that conviction histories would be something that appear after it's deemed whether or not someone would be a good tenant and they could pay the bills. It would prohibit landlords from asking for applicants about their conviction histories during the initial screening process. It would postpone a background check until the applicant receives a conditional offer. It would limit the use of system involvement in corrections. And then once the tenant has this conditional approval through the screening process, then there would be a chance to take a look at the criminal history, and the landlord would have to provide a reason why they are not going to rent to someone for a rental history I'm sorry, a conviction history that really doesn't have anything to do with their ability to uh, be a good tenant. I, Rachel, would it be appropriate for me to stop for questions right now of the legislative agenda, or do you usually do that towards the end?
So normally we keep the questions at the end, but if there are any questions, folks can feel free to pop them into the Q&A. This is a good time as any. Andrew, because you happened to get into the chat before I actually posted anything in there, I did see your question about the court ruling on Mr. Johnson's residency and choosing not to appeal. That's essentially what's going on with the special election coming up at the end of the month, correct? Okay,
Correct.
gotcha. So covered that. Um, and I don't see any other questions coming in on the Q&A. So if you want to pass it along,
Yep. No, but let's go to the next slide, and I'm going to start by sharing a bit about our tenant bill of rights.
perfect.
Um, we believe that there should be the right to a fair application process. Searching for a future home is costly and it's stressful for many renters. This is especially true if you're low income, if you have a checkered past, or if you belong to a population that must often contend with prejudice and discrimination. We think reducing the unnecessary costs and barriers and addressing discrimination will make for a much fairer application process. Under this item, we have 3 or 4 different policies that legislators can pursue to make for a fair application process. And again, you can find those items on our website. But we want to make sure that there's balance in place as tenants are applying for an apartment. Next slide. Okay. So the right to a fair lease. Um, as I said, landlords write the leases, and unsurprisingly, rental leases are written to protect landlords' interests more than tenants' interests. It's just the landlords are writing them up, and so it's going to cover some of the things that they have concerns about more. Tenants can rarely negotiate the terms of a lease, and they've been presented with because the landlord may have other people next in line who are willing to accept the terms of the lease. Minnesota law should correct this power imbalance, and there are a number of proposals that we have that we made last year and are willing to work with legislators who want to make the lease process as fair as possible. Next slide. Next, we want to make sure that tenants have the right to a habitable home. Everyone deserves a safe home. However, tenants usually do not have the authority to make their own repairs. They need to rely on a landlord to keep the place properly maintained. But too often, this leads to delays in making repairs and not getting them done at all. Obviously, there's a lot of landlords that make repairs on a timely basis, but it's too often where this is not happening. And so we want to make sure that the tenants feel all right making requests for repairs. Right now, there's many of them that feel reluctant because they fear retaliation. There can be policies that are put in place in the rental to make rental housing fit for the intended use and livability purposes, and that tenants would um, make sure that the rental stock that they're having the ability to apply for is safe and quality housing, and if not, that they have a way to actually make the place that they're living in habitable by making demands of the landlord um, to make repairs in a way that is not going to encourage retaliation. Next slide. Um, Reasonable rents. That's something we all would hope for right now. It's the rental market, as the housing market in general, is not a very friendly place for the consumer because there's just incredible demand. Rents have increased relative to incomes, however, for the past several decades. I've been doing this work for 30 years now, and I remember reading a legislative auditor's report on affordable housing saying that in the 1990s, um, rents had outpaced low-income tenants' income significantly. And we got a report that said some of the same thing happened in the 2000s and the next decade, and now we're in this decade. And we have a report from the National Low Income Housing Coalition that says that if you're working at the current minimum wage in Minnesota, you need to work 82 hours a week to afford a modest one-bedroom fair market rate apartment. To make things even worse, there are only 34 affordable and available units per extremely low income, 100 extremely low income households. Let me repeat that. Um, there are only 34 affordable and available rental homes um, that exist for every 100 extremely low-income household renters that need them. Protecting tenants from excessive rent increases in this environment is something we want to encourage. We think it'll make for greater stability of renters and also the stability in their communities. So, next slide. The next right that we assert is that there should be a balanced power in court. Rules mean very little if there are no consequences to breaking them. And in the most recent decade, there are good laws that have been passed that are supposed to ensure that tenants are treated fairly, but they lack any enforcement method. In some cases, this means that there may actually be no penalty whatsoever, dollar-wise, for a landlord uh, uh, who breaks a rule. Um, so without there being a fair enforcement effort, tenants have no way they can actually get landlords to follow the rules, and then there's a little incentive for landlords to comply. And again, if there are no consequences for breaking a rule, it's really not a rule at all. Additionally, the courts are unaffordable. They're unfamiliar places for renters seeking remedies to address the violations. It makes them reluctant or unable to pursue what enforcement options do exist. And lastly, landlords frequently benefit from attorney representation, but tenants often have to navigate the process independently, putting them at a disadvantage. We want to put some teeth into Minnesota law so that it expands access to the courts and helps renters better use the legal system to their benefit as well. So that's the right to a balanced power in court. And we'll go to the next slide, which is a right to safeguard against evictions. Evictions are right now, I forget if it's our number one or number two most called item, but we are at very high levels of evictions each year. I believe that um, uh, we're not in a record year. Last year wasn't a record year, but it was pretty close. The year before that, I believe, was a record for evictions. We need to do what we can to not have people be evicted and instead remain in their homes. Um, so evictions and sometimes involuntary displacements that are initiated by landlords disrupt households, disrupt communities. We think that landlords should have to have just cause before they end a tenancy, as I said earlier. Um, but that is not the case right now. Beyond affordability issues, tenants need to make notice to landlords when they claim that lease violations are taking place, and that they are able to do this before taking matters to court. The court is a costly process. And then a few other things that we list as protections in the safeguarding in an eviction process or preventing an eviction. Next slide. And then the right to clear rules. Many landlord-tenant laws are not clear. They lack clarity that affects landlords, and this lack of clarity affects landlords, tenants, the advocates, the attorneys, the courts, and anything we can do to clarify the rules would be something that we think is something that should not just be the rights of tenants, but also make the process better for everyone involved. Okay, next slide. Um, We talked about the context of this legislative session, and we're not certain if there's going to be power sharing or if there's going to be one side having more power versus the other in the House of Representatives. No matter what happens, we're going to have to do some things that we think that we need to pursue some items that we think can approach something like a consensus, or at least we reasonably agree that some problems exist. And so Homeline is putting forward a common sense proposal that has 5 components. The first is that a residential lease should not list a minor child of that residential as a residential tenant. Minors are, it's okay to list them as tenants, but if you name, I'm sorry, it's okay to name them as occupants. But if you list them as tenants, that means they become legally responsible for, or that makes it seem like they're legally responsible for what happens in an apartment. So, for instance, let's say an adult in a household loses their job, can't pay the rent, an eviction action is filed against them. Sometimes an eviction action is also filed against a minor, even though their parents were the ones who couldn't pay the bill. And we think that this is just uh, this has to change. It's not something that happens a lot, but when it does, it can have a tremendous impact on the youth who may be a year or two from moving and may find it incredibly difficult to find a landlord that will rent to them because an eviction action is on their record for something they really had no responsibility for. Second, we think that a tenant has a right to see the unit that they are renting before they sign the lease, not just seeing a model unit. And so this right could be used either by an actual tour of the place or a remotely showing the tenant the apartment that they will be moving into. If the tenant is actually a youth, let's say there's an emancipated youth, and they are the one signing the lease, then they would be responsible for the payment of the rent and taking care of the apartment. And so a landlord could take action against them, but that's a really limited situation. But again, if there's an adult that I'm sorry, I went to the previous item, so my apologies. Um, the third item that we have on our agenda off this common sense proposal is that there be the right to no unilateral mid-year lease changes being allowed. There are some leases that are on the internet that landlords download, and they have a clause that may say that landlords can change the lease at any time. And we think a contract's a contract. If both parties sign a lease that lasts for a year, that they um, hold to the terms of that lease, and that it should be illegal to have give the landlord the ability to change the lease. The tenant certainly doesn't have that right, so the landlord shouldn't either. Fourth item on this list is that a landlord must provide contact information, which would include an address within 50 miles, a phone number, and an email so that a tenant knows who to contact if there's an issue that they need to have addressed in their apartment or in the apartment complex that they're in. Common response, a common example of this is um, if a repair needs to get made, but the tenant actually doesn't know who the landlord is. They just have a PO box that they send the rent checks to. But when they send a request for repairs, there are cases where someone doesn't know uh, who the landlord is. And I've received some calls from some some lawyers who are representing tenants, and they're trying to find out who they're actually renting from, and they have a PO box or a commercial box in Texas. They've been paying the rent regularly for many months, but they've made requests for repairs to be made, and they get no response. And we just think that that's something that a policy like this would help change. Um, so whether or not you're in state or out of state, that you would have a contact in a very within a 50-mile radius, along with this contact information. And then lastly, that if a tenant, the tenant may actually break the lease if their landlord hasn't followed the Koskinen Act. Basically, the Costigan Act, which is already the law, says that landlords are supposed to put all managers through a criminal background check before they're able to have the set of keys that allows them to enter an apartment to address a situation. Um, there was a case many years ago where a tenant was murdered, actually murdered. Her name was Kari Koskinen, and if a background check had been done on the one of the managers, that this issue would have been caught. Um, and so we're saying that if these background checks aren't being done, that the tenant has the right to break the lease. So that's our common sense approach, a proposal that we have out there. Um, let's go to the next slide. And Larry, would you want to go over the technical amendments?
Sure. Thanks, Michael. So when we were, so there were a lot of things that were passed in 2023, but there also were a lot of things that kind of got left on the floor. And sometimes that was a policy decision by committees, but sometimes it was a committee passing on one part of a larger bill and not seeing that leaving out another portion of the bill would create a gap. And so we believe there's a need for some technical amendments to deal with that. So the idea behind these, and we think these are also common sense because they're not intended to change the law, but fill in the gap that happened when essentially a cross-reference didn't happen, or there was some language that worked kind of awkwardly with the real world. So the first is that there were several laws that had effective dates that were limited. So saying that January 1, 2024, applying to leases signed on or after that date. That's fine for those, but what that left out were leases that hadn't expired. And some leases go for a long period of time, like a year or maybe more. But also, there are leases that aren't signed. A lease can be a written document or it can be an oral agreement. So if I decide I want to rent from my landlord and we don't have a written lease, nothing has been signed. So the idea was to and it makes it difficult for landlords and tenants and judges to know, well, does this law apply to my lease or not? And so the idea would be to make the law on the effective dates a little more expansive to be consistent with what other effective date laws have said. So our proposal would be to expand that to include leases signed, entered into, renewed, or extended on or after that date. So that would really cover anything that started after that date, but anything that kind of renewed after that date, whether it was an oral or writing. As you can see at the list at the bottom of the slide, there are quite a few of the new laws that went into effect January 1, 2024 that were in this kind of precarious position in terms of figuring out where do they apply and where do they don't. Next slide. So another area of confusion is the list of definitions that in 504B001 that refer to the word violation was expanded from 3 topics to 5 topics. So previous to 2024, the list included number 1 and then included included number 1 and number 5. I'm not sure, I'm kind of spacing out what the other one was. But anyway, it was expanded to go 1, 2, 3, 4, and 5. There are a number of laws, so that simply says what a violation is. It doesn't say what anyone can do about a violation. And the problem is that other laws that cross-reference this statute weren't changed to go from 3 to 5. So those still refer to either 1 and 2 or 1, 2, and 3. So that means that 4 and 5 basically don't have a remedy for a violation. And that's certainly not what the legislature intended. Otherwise, why expand the violations? So the proposal here would be to make those cross references. So for instance, in a rent escrow action, a tenant could pursue violations of any of these 5 rather than the first 3. Next slide. And the last for technical amendments is the legislature authorized the Attorney General to enforce the landlord tenant chapter, which is 504B, and put that in a law in 504B. It's 504B.501. But it did not list 504B in the Attorney General's enforcement statute, which is in a different area. That's in 8.31. And that has a whole list of laws that the Attorney General is authorized to enforce. And so to be consistent, adding 504B in this statute for clarity would mean adding 504B into the list in 8.31. Next slide. So now we are open for questions.
And Rachel, before you
Sorry.
pop us into some of those questions, I want to encourage folks that if you want to have questions about both the technicalities of our bills or how they would operate, also welcome to people asking about how they can get involved. So this is a chance for us to do what we can to move our policies forward, as well as describe what we're working on. So I'd love to hear questions you have regarding that as well.
Sure. I think while I'm getting all of that sorted out here, I'm also going to plug in another thing that Homeline is doing with our grassroots organizing, looking for stories of people who may have experienced source of income, you know, discrimination or denial or something like that. We are collecting those stories. One of our new hires, new staff, Fatima, is collecting those. So I will pop her email into the chat here in a second.
She's also covering just cause eviction protection. So if there's been a displacement that's come at the end of your lease, we're collecting stories about those as well. Um, and we think that we've got some pretty powerful ways that we can share stories with legislators, and we'd love to involve those who have had to deal with these issues and want to be involved in some way in the legislative process.
All right. All right, so we got a lot of questions pre-submitted this time around, which was awesome. A lot of them are very kind of specific to an individual's experience. So I'm going to try and focus quickly on any of the questions that are specific to kind of the legislative process and agenda. And then I will, and Larry, if you want to hop in with your vast pool of expertise in this area of law, Larry and I can try and tackle some of the more specific legal questions. Um, so first off, is there, this is a question from Shannon, and this is a question mostly for Michael. Shannon is a service provider. I believe she works with a pit bull rescue. And they're wondering, do you have any data around pets? We're hoping to introduce a pets and housing bill and would love your support. So um, I don't know if that's something that we have at all, but Shannon would like to
Uh,
know.
I'm sorry, I can't answer this question. I know that the Humane Society brought forward the law that dealt with you can't if you allow dogs, you can't force declawing or devocalization. So I guess I would check with the Humane Society of Minnesota to see if they have proposals that they're bringing forward to the legislature this year. Um,
Mhm.
but thus far, we don't have anything on our agenda that covers this area.
Gotcha. Um, so then Ruth, it looks like Ruth's question got cut off, but Ruth was talking about tenant and future tenant protections being enacted to protect folks who are rejected for misdemeanors on their records. So,
So
mhm.
I'll ask for a little bit of help from the two of you. But one reason we're supporting the Fair Chance Housing Act is that we want there to be the actual, can the tenant pay the rent and be a good tenant? And that those questions get asked or seen through an application process before criminal history is asked about, and that the landlord would have to provide a rationale for why they aren't going to rent to that tenant in a reason for a reason that really impacts the other residents, whether or not there would need to be a concern that other residents need to have. And so our hope is that that legislation is able to move forward this year, and uh, we would keep more serious matters as where denials might take place, but not ones that aren't uh, dealing with things like violence and other issues like that. Larry, would you have anything to add to that, or Rachel?
No, I think that covers it.
Yeah, there's already we're supportive of legislation, but that there's already other groups who are taking more of a lead on that, is what it sounds like. All right. Tiffany would like to know, is there any update on the retroactive language that was approved for expunging evictions 3 years or older? And how will this be completed?
What I'll say is that no, there hasn't been clarity on that, and that's one of the things that we would like to have done, and that is part of our proposals to do that. So the question is getting at the expungement law was expanded to have automatic expungements in certain categories, and one of those categories is evictions that are 3 years old or older. And the intent was to have those older cases basically fall out of the publicly available records. And at this point, we have not seen that happen, and we're hopeful that we can get something passed that makes that more clear. That's what's supposed to happen. I think some of the resistance in the court system has to do with how to manage that from a computer technology standpoint.
I will say that last year the legislature appropriated funds to the judiciary to cover the expense of doing those expungements. And so our hope is that that if that was one of the barriers and that was one of the barriers, that helps move this issue along more quickly.
All right. Okay. So then, um, Ricardo, tenant, had just wanted to know about source of income discrimination in regards to vouchers. You already kind of mentioned that. I'm desperately trying to type up Fatima's information in the chat while also navigating the question. So I will get that to Ricardo if you're on in just a second for her contact info. Um, So that is really the specific kind of questions regarding the legislative agenda that came up previous, that was submitted before this. We do have quite a few actually that have come through during. So let's go into the Q&A. So Ruth is about emergency funds. They're saying there's concern about availability of emergency funds for people who are just above the qualifying level. So do you have any comment on that?
Um, Not specifically, I'm not aware of this issue specifically. I do know that um, this year it's going to be a difficult year to secure additional resources overall. And so the amount that is necessary for emergency rental assistance for those who qualify or are just over being qualified is something that we should be concerned about, but we also need to advocate for. And so, my advice to people who are just above the level of being able to receive assistance, please contact your legislator and let them know what the problem is, how you don't fit the current uh, standards, and that you would hope that there would be a more expansive definition of who would be eligible for emergency rental assistance. Uh, it's going to be, again, as I said, it's going to be hard to get the amount of resources that we seriously think are needed. But the only thing that changes that is people power. And so please contact your legislator. And if you don't know who your legislators are, um, send an email to me and I can help locate that for you and help you make a pitch to your legislator as well.
Right. You can also find it, your legislature, legislators at, all right. The Minnesota legislature website also has a who represents me function if you want to use that way. Otherwise, yeah, Michael, if you want to drop your email in the chat, that would be great as well. All right, thank you. Moving on, Anonymous wants to do a slightly deeper dive into this landlord database. So they say, I like the suggestion of a database of landlords. Would this potentially include information whether they accept rental assistance? I would suggest also including whether they will work with applicants who do not have a social or an ITIN. I'd like to hear your thoughts on this.
Um, we are not the ones pursuing this legislation in particular. We're supporting it. Um, um, what I can promise to do is pass along your question. If Rachel, if you could find some way to cut and paste that for me and as something that I can pass along, that sounds like really helpful information to have.
Sure.
And I can see if that's something that can be pursued this session. And if the answer is yes, I certainly will get back. Oh, it's an anonymous person that asked a question, isn't? I'm going to tell all of Minnesota what the answer to this question is.
Fair enough. Otherwise, Anonymous, if you want to connect off this Zoom meeting, feel free to reach out as well.
But I
Um,
will certainly pass along those issues to the organizations that are pursuing the database or that the Minneapolis is pursuing regarding the database.
yep. All right. Yeah, I will say just to pop in a second. So the legislature just passed a law that went into effect a couple weeks ago regarding ITINs, basically saying that they have to accept an ITIN in lieu of a social security number if that is what the applicant has. Um, so that is also something that's a fairly new addition to 504B.
Thanks, Rachel.
Yeah. Okay. So Jennifer has a question about in public housing and other subsidized housings, there's required leases and lease addendums that have to be used. How do you address these leases? So I believe that came up during the kind of uh, the five common sense questions.
Mhm.
So how do those issues or changes or, requirements, how do um, those interact with public housing or any other subsidized program that may have a very specific lease requirement?
Yeah, well, landlords that operate subsidized housing programs, that includes public housing, Section 8 vouchers, low-income housing tax credit, there's a whole alphabet soup of the different programs. They all have to follow federal law of their programs and state law. And to the extent there is local city law, they have to follow that as well. And so that means that those landlords have to be attentive to changes that happen at all three of those levels. So as an example, landlord in public housing, there's a law or landlord and subsidized or public housing. There's a federal law called the CARES Act that requires a 30-day notice in evictions. We have a state law that requires a 14-day notice in non-payment of rent cases. We have several cities that have notice requirements. So a landlord, for instance, a landlord in Minneapolis would have to follow both, who's in subsidized housing, would have to follow the CARES Act requirement, the state requirement, and the Minneapolis requirement. And it's not rocket science to do this. You just look at all three of them and you build all three of them into the same notice that complies with all three, and then you're good to go. But that's just one example. So the landlords that are in these programs, it's on them to follow these developments and to adjust their leases accordingly.
Fabulous. Thank you. Okay, Kim has asked a couple times about housing choice vouchers, and they're saying that their landlord is allowed to raise the rent anytime they want. What protections are you planning to do with this?
Well, first of all, they're not allowed to raise the rent to the tenant anytime they want. So the way the vouchers work is that HUD puts a ceiling on how high the total rent can be. And they publish those ceiling rents, it's called fair market rents, every fall for the next year. And so there's a fair market rent schedule for instance, the Twin Cities. Then under that, the tenant pays approximately 30% of income for rent. I say approximately because there are some adjustments in there. So what really affects a voucher tenant's rent are changes in the voucher tenant's income, not what the total rent that the landlord's charging. If the landlord is under the fair market rent cap and wants to raise the rent $50, the total rent, that would be paid out of the HUD subsidy, not out of the tenant. For anyone who's having rent calculation issues in any kind of public or subsidized housing, the first place to go would be to your local legal aid office. I used to work at one of those, and we did that kind of analysis and work all the time.
Yep. And I just dropped the fair market rent calculator in the chat. It's something that you can access online fairly easily. It's determined by county. So, all right. Thank you, Larry. All right, looks like we've got some Ruth questions specific uh, to these topics. All right, one of them is more a general question, but Ruth just wants to know, is tenant organizing in market rate apartments important?
Well, it's very important.
Yep.
And we do organizing work at Homeline as well, and other organizations do that as well. One of the laws that got passed in the last year was to make clear that tenants have a right to organize and to be on the property to do that, and to have organizers on the property to help them.
Yeah, that was tenant right to organize. I'm grabbing that statute number here, but it's important for any tenant, right? If there are issues that need to be addressed on a building-wide basis, then organizing is a great option. All right. So then, okay, that's kind of the what I see for the policy questions here. So we've got about half an hour left. Folks, if you have questions about policy or kind of the upcoming legislative session, I won't promise that Michael will have all of the answers and the crystal ball of what the heck is going to be happening this session. Um, if you do, please share those secrets, Michael. But otherwise, if you've got questions about, policy, or if you've got suggestions or, things that you'd like to, you know, talk more about, feel free to drop those in and we'll get to them as we can. I want to go back to our pre-submitted questions. And then, Larry, I'm going to lean on you probably for these quite a bit. Um, we can sep not separate, we can rotate, but um, I'm just gonna go first with Arthur. They're a tenant. They're looking for housing help for students. Um, if you are a U of M student, University of Minnesota student, they actually have their own separate student legal services. So they're a really great resource if you're a U of M student. Otherwise, if you are not a University of Minnesota student and you're looking for kind of legal help, Larry, do you have any suggestions there?
Yeah, well, first of all, if you have landlord tenant questions, you want to know what your rights are. One of the main things we do at Homeline is operate a hotline where we answer those questions. And they come from old people like me, and they come from young people and everybody in between, whether you're a student or not. And there's no income qualifier for that. Now, there are a lot of students that have low incomes and would probably qualify for free legal aid. And there are legal aid programs in every county in the state. So those would be places to get some help.
All right, next question for you. Um, so what happens, this is from Denisha, who I believe is an attorney, and they're wondering what happens if landlords are raising rent more than 3% in St. Paul and the tenants are too afraid to speak up because of retaliation?
Well,
Nice, easy question for you there.
well, that's always a challenge for tenants enforcing their rights. We have pretty good anti-retaliation laws in Minnesota. And they've been supplemented by some recent court decisions as well. So it is illegal for landlords to retaliate against tenants. Um, but the challenge for any tenant is there, unfortunately, are ways to subtly retaliate that are hard to stop. Um, Anyone who's been in a workplace who's had an awkward relationship with a co-employee or a manager, there are ways that people can make other people's lives not that happy without doing big dramatic things. So whenever a tenant enforces his or her rights, there is some risk that the landlord is going to try to um, do things that are going to make that tenant less comfortable. Um, and but at the same time, the anti-retaliation laws make it pretty clear that if the landlord raises the rent in response to a tenant making a complaint, that's going to be retaliatory. If the landlord gives a termination notice to a tenant within 90 days after a tenant has done something to enforce his or her rights, that's going to be presumed to be retaliatory. So there are really good laws out there. And what I've been telling tenants for a long time is that you're actually better protected for security in your tenancy when you complain than when you don't. And I'm not encouraging people to complain about nothing, but I am saying that if you complain about rent increases or habitability problems or anything like that, and the landlord takes some adverse action against you in the next 90 days, it's going to be presumed to be retaliatory. And the landlord in a court case is going to have to disprove that, to come up with some other big important reason that has nothing connected to the tenant enforcing his or her rights. So let's say there are a bunch of repair problems and the tenant complains and the landlord raises the rent or gives a termination notice within a week or two. The tenant's going to have, I think, a decent chance at um, forcing the landlord to pull back on that and not do it. But if the tenant never complained about the repair problems, and then the landlord raises the rent or gives the termination notice, then it's hard to show that that's retaliatory because the tenant hasn't expressed that concern. So it's and I'm trying not to make light of this because everyone has a different sense of risk taking, for instance. And so I've certainly had, I've got probably over 11,000 former clients over a long time of representing tenants. And you could take two different tenants with the same situation, and one is going to say, I want to fight for this. And the other is going to say, no, I just don't have the mental energy for it. I don't want to take the risk. And there's nothing wrong with either one of those choices, as long as tenants know that they have the choice. So any tenant who's facing rent increases or facing repair problems, other types of problems with their landlords, they should get some legal advice about where they sit so they can make an informed choice about do they want to fight it or not. And good places to get that advice are the Homeline Hotline and also for people with low incomes by going to their local legal aid office.
Awesome. Thank you, Larry. I'm actually going to switch it over to Michael here quick, because we got a couple of general, essentially complaint topics here that I want to see if there's any traction at the legislature for, kind of addressing those, or, if that's in Homeline's plans or some of the cohort plans. So Ruth is asking about tenants are required to pay by portal, like that's the only way they're allowed to pay their rent. That causes problems. And Donna is talking about safety and security in the apartment complex and whether, you know, how, are there any, sometimes there are issues with that. Are there any places that the legislature could, or is intending to step in and kind of address those two issues?
Looking backwards, I guess I'll ask Larry and you if there are particular things that can happen to protect people right now. I am not aware of either of those issues as being ones that are being pursued at the legislature this year. Again, that doesn't mean that it shouldn't be addressed. Um, uh, I sound like a broken record, but first of all, raising the issue with us is great. And uh, we would certainly consider in future years putting something like those matters on our legislative agenda, or this year contacting organizations that are closer to those issues um, and and seeing if we can do a partnership to address the problems. Um, the other way to help address this is quite honestly to contact your legislator directly and say that this is a problem that you're facing, and that you hope that the appropriate committees, which are usually the Housing and Judiciary, would take up these matters and find a way to fix them. Um, I'm not trying to brush this under the rug and say Homeline isn't going to do this. We certainly want to partner with legislators that are interested in issues like these things to happen. But there's always a matter of capacity and what we think we can accomplish. And so I'd want to know more details about the situations that you're interested in pursuing, and find a way for me to say this is something Homeline can do, or we can help locate the right group to help support it. Um, but again, I haven't seen anything that deals with these two particular issues as moving forward at the legislature this year yet.
Gotcha. All right. Um, da, 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 da. Actually, Michael, I'm going to keep you in the hot seat here for a
Okay.
second. Kind of going off of Denisha's question related to the rent caps in St. Paul. Mindy was just asking about increased rent, and rent increases are a big issue for lots of folks. Is there, can you talk to us about statewide rent control or rent stabilization or any of its myriad of iterations?
So again, if there's help that can be provided, I'm not saying things completely accurately, please jump in, but the state of Minnesota has a provision that says that a city has to go to its voters for a decision about whether or not rent control or rent stabilization is something that they can do in their community. It's, there have to be a certain number of signatures that are gathered and verified, and campaigns that are required on a local level to make these things happen. Um, uh, it happened in St. Paul, but unfortunately, it's gotten watered down significantly, which is very concerning to Homeline, considering that um, new buildings are exempted, and forget the other issue area where um, the right no longer the rent stabilization ordinance no longer protects the group. But I will say that there's talk about actually moving backwards on this issue on the state level. There are legislators that are saying that they should repeal the statute that says that cities have the right to do a referendum to cap rents. And so if we're going to impact this issue, it's one where individual legislators need to hear that this is, again, something that is not supported by their constituents. So sorry for the bad news, but that's where it is right now. And I don't see rent stabilization measures being strengthened on the state level this next legislative session. Just the political makeup does not make it seem like that's something that we can move forward on. So local efforts really are the way to go if there are desires to make that happen. And I also don't want to make light of the amount of effort it would take on a local level for that to happen, but at least there are examples of cities where rent stabilization have been pursued. Um, and it takes a lot of following up on the matter because attempts to water it down once it's in place um, uh, come come to bear pretty quickly. The last thing I'll say is that there are some uh, there are some folks out there that are saying that rent stabilization hurts development of housing in a particular community. Um, and especially because St. Paul's ordinance was watered down so much, um, we don't know what evidence people who are saying this, what they're relying on is actual evidence to say that this is the case. And so, we think that reasonable efforts to stabilize rents uh, are good for consumers, helps people afford rents, and that more communities should be doing what they can to help address this matter, whether or not it's through rent stabilization policies or other ways that they can help low-income renters cover the cost between what the rent is and what they can afford.
Awesome. That is an excellent answer. Thank you, Michael.
The thing I'll add on rent stabilization is, unfortunately, sometimes when there's progress, there's a backlash. And if my view nationally, that's part of what's going on right now. And what happened with rent control, St. Paul tried to pass a rent control ordinance back in the early 1980s, and I actually worked on that. It was unsuccessful, but that led to the landlord lobby going to the legislature and getting a law that would make it really hard to pass rent control. That law is there. Rent control can be passed, but it's very challenging to navigate it. Both Minneapolis and St. Paul did, and have then St. Paul got a little bit of backlash on that. If there were a repeal of the whole rent control law in Minnesota, that would actually allow cities to do rent control if they wanted. I think probably what's being discussed is repealing part of the exception in the rent control law that allows Minneapolis and St. Paul to do what they did.
Thank you, Larry.
Yeah, and I was able to find that statute number after some digging. So it's 417.9996. All right. Awesome. Thank you for that discussion. I know it's a hot topic. All right. Another hot topic. Let's combine some more questions here. Repair issues, but specifically mold. Everyone's favorite M word. Um, so for one, is there any kind of discussion about mold issues? We're seeing these kind of becoming more prevalent in the recent decade, of mold issues cropping up for tenants especially. But what do tenants do if they've got mold? And is there anything, I would say, Michael, at the state or local level that you know of that's addressing mold issues?
Well, first I'm going to ask you, Rachel, because you deal with this on a regular basis with tenants asking what the current situation is about. How how do you address mold issues and how complex is the matter? Because it's pretty hard to prove that a certain mold is a problem, in my understanding.
Mold is a mess. Um, so mold impacts people differently. Some people, like, mold doesn't bother them at all. It's not a big issue. Maybe it's a little, and also like the scope of it is like a little bit of mold in the, somewhere, or is it like taking over your wall? Like obviously context is important, but like, are you somebody who is very medically impacted by mold versus someone who may not even register its existence in their body? Like, so mold can have differing impacts on folks, which does make it a little bit more difficult to kind of pin down whether it's like an emergency situation or not for folks, I find. But um, unless you yourself are a mold expert, it's always good to get expert opinion about whether that black swatch on your wall is mold or mildew or some weird, I don't know, left over from a really old peanut butter jelly sandwich. I don't know, right? Like if it's an unknown substance on your wall, it's best to get an expert opinion about what that is first, is general my kind of 2 points there. But I'm going to turn it over to y'all that while I go and look for, I don't know, any local or state mold related issue.
Well, what I would add about that is landlords presently have an obligation to maintain the property in reasonable repair, in compliance with local codes, and in compliance with and fit for the use intended by the parties. So that's an aspect of Minnesota law. And so if the landlord's failure to deal with mold problems seems to me would fit into those categories. So for instance, that it would be not in reasonable repair to have mold that is impacting a tenant in a negative way. And so one of the things would be to try to figure out with a medical professional if a tenant is being affected by mold. The tenant's being affected by mold and that determination is made there, then unless the tenant is spending a lot of time somewhere out of the apartment where there is mold, then that's going to support the argument that there is a mold issue in the apartment, regardless of whether the tenant has been able to get that mold tested. The other thing I would add is that federal law and state law requires landlords and other kind of actors in society to reasonably accommodate people's disabilities. So if a person has a disability that makes them particularly susceptible to mold, so that might be asthma or might be some other respiratory condition, the landlord has an out, and let's say I have that condition and Michael doesn't, and let's say we're both tenants in the same building. The landlord might have an obligation then to make my unit better for my health concerns because of my disability than for Michael not having that kind of disability. So those are a couple of different areas that could play into this. A good place to get some advice and analysis on this, especially if your income is low, is to go to your local legal aid office.
Okay. Um, I will also say that a lot of city inspector offices do not have the expertise to say definitively whether something is mold or not. And so I think that is something that is being eh, addressed in some, inspection offices. They are getting that expertise, but it's, as far as I can tell, slow going. But I believe Minneapolis is got some more stringent requirements regarding mold in their ordinances that were recently passed, but it's going to be kind of a, beyond the general, repair requirements, like if trying to identify mold and then get the landlord to actually fix the problem, uh, what you laws you have to rely on are going to be kind of piecemeal depending on where you are. So, all right. Let us go. Oh dear. I was so busy looking for ordinances, I clicked out of my questions. I'm sorry, y'all. Hold on a second. All right.
I just posted in the chat the Minnesota Department of Health webpage on mold.
Perfect. Thank you so much. All right. Um, so then let's see what we got here. Uh, the okay. Here we go. I like this question. When is a lease considered out of date? Why do landlords alert a resident of complaints to avoid surprise evictions? I'm not quite certain what the second question is asking, but I just enjoy the when is a lease considered out of date?
Well, the short answer is whenever it doesn't comply with the law. And so if the law changes and the lease is not changed to be consistent with that, it is out of date. Um, the other way a lease, I guess, is out of date is if it's expired. So like if you have a 1-year lease that went to the end of December and now we're in January, then that lease would be out of effect unless there's some language in there about what happens after the end date on the lease.
And is there, I guess, can say, for example, a verbal lease be out of date?
Well, most verbal or oral leases don't have a lot of meat in them. It'd be kind of unusual to have a landlord say, okay, here's our lease, and these are the 25 do's and don'ts, but I'm not going to write them down. I'm just going to tell them to you. Um, Landlords generally are better protected when they have written leases because they can put all those 25 do's and don'ts in there as long as those are not illegal. So oral leases tend to be pretty Spartan. Might say this is what the rent is, and this is the kind of notice that you need to give. Now, just because the oral lease doesn't have much in it, doesn't mean that there isn't a lot of law that applies. So, for instance, our habitability law applies whether you have a written lease or not. Our security deposit law applies whether you have a written lease or not. So oral leases tend not to get out of date because they tend not to have the level of detail that could run into conflict with laws that change.
Awesome. All right, we are at 2:55 according to my clock, so we've got just 5 minutes left of our time here. We still have a lot of questions that are kind of coming through that are more general, but I want to touch on some of them as we can. Um, so we've got a whole bunch of questions. I want to preface this first. We have a whole bunch of questions that are very specific to an individual's experience or um, issue. And so I definitely am going to reiterate again, please give us a call here at Homeline or give your local legal aid office a call. Um, Especially if you are a low-income tenant that is facing an eviction. Legal aid is a great resource for that. But Homeline,
And the
you
thing,
know,
and
we,
the thing I'll add, the
Mhm.
thing I'll add to that is, a 1 minute response by us to a question is not really giving you the amount of time that you need. I
Yeah,
mean, and so better to have a 15-minute or a half an hour conversation with someone than to have us answer it kind of generally in a minute.
yeah. And I'll say Homeline's been here for over 30 years at this point. Like we have seen these laws come and go, how they've changed and evolved over the years. We have access to Larry as a really great resource. He literally has written the book on tenant landlord law that we reference. Uh, I call it Larry's tome. It is quite useful and extensive. So what I'm trying to say is like you know, we have seen just about everything here at Homeline. And so we um, welcome your questions and, that's what we're here for, right? So if you, um, uh, okay, so we've got Kim had popped, all right, Ruth had popped in with eviction cases where the landlord turns off a portal between when the case is filed and when the hearing happens, tenants can't make any rent payments during that time. Is that a problem? Like, is that going to be, is that illegal for the landlords to do? Is that like, what's the, can you talk about that real quick?
Yeah, so that one's a little bit tough to answer without knowing more about it. So let's a landlord has to accept the rent from the tenant when the tenant's paying it, but there is an exception. Let's say the landlord's given a tenant a notice to move out at the end of December, and the tenant hasn't moved and now wants to pay the rent for January, and the landlord really wants the tenant to move. The landlord can say, I'm not going to take the rent. You should have moved. And if you don't move, I'm going to file an eviction case against you. Now, that same landlord, if the landlord was collecting rent through a portal, could do that as well and say, I'm not going to collect the rent through the portal because you were supposed to move. Okay. So that's kind of a general answer that it may or may not be legal depending on the circumstances.
Perfect. All right.
Rachel,
Uh,
I'd like
yeah,
to use this last minute that we have just to
hmm
reiterate a couple of points here. Uh,
please.
a couple of things. Homeline is working in coalition with a number of groups again uh, for source of income protections and for just cause protections as well. If you have a story to tell about how these issues have impacted you adversely, we really, really, really want to hear your story. And so I would uh, access the information that Rachel put um, in the chat function to contact Fathermo at our office, and she is collecting those stories on a regular basis. Um, it's it's something we need to keep at the top of legislators' minds during this session. Also, if there are other things within our legislative agenda that apply um, to to you, um, and you want to know how our Minnesota Tenant Bill of Rights impacts might help you in a particular situation, to please email me, and we'll do what we can to try to get your voice heard by the people that need to hear it.
And last but not least, I know we had some really great questions that didn't get answered. Come back in February when we do our Q&A session and ask them then, and we'll have a panel of attorneys to address them as well. All right, so thank you so much, Michael. Thank you so much, Larry, for sharing your information expertise. Really appreciate it. Thank you all for joining us today. I hope you have a great rest of your day and you take care and and uh, good luck, everyone. Bye.